right, everybody. It's Thursday or Thursday. Welcome back to Law and Legitimacy. And let's be mindful, shall we? Take a deep breath. Inhabit your skin. What do you see? You see a world out of fucking control. And you didn't come here to do meditation exercises, helpful though they may be. What you came here to do is take a look at the roiling chaos in the world around you and ask you, WTF does it all mean? We don't know either, but we're trying. And we're trying to put things in context. We're trying to point into a direction that will move us from where we are today to where we're going tomorrow. And you're thinking, wait a minute, is that bad rock and roll? Time keeps on slipping into the future. Yeah, of course. We all live on the cutting edge of experience. What I just said was the past. What I'm about to say is the future. What I say now is the present. But the moment it pops out of my mouth, it becomes the past. You know, if you want to start parsing life on that metaphysical fine edge, live in a cocoon, okay? Because reality requires that you divide your experience into discrete bites and to discrete blocks of and units of things. That's why culture, that's why ideas, that's why the ideas of society, philosophy, and law matter so much, because these are the building blocks of the lives that we live. And what they do is they make possible for the lucky among us spaces in which we can experience the internal richness of life and confront such things as the dilemma of time. I mean, you know, for example, time. Are we in time or is time in us? Those of you who have been bored know that a second can seem like an hour under the right circumstances. If you've been ecstatic, an hour can pass and it'll seem as though a second. So time is in you in that respect. But the time that's passing on our clocks right now, well, that's outside of us. And we're united together by common conceptions, not just of right, but conventions about time. So let me stop wasting yours and get down to some meaningful stuff. Fani Willis. Or is it Fani? I mean, so Scott McAfee, the 34-year-old jurist sitting on the Georgia RICO cases, did sign a certificate of immediate review for Trump's appeal of McAfee's denial of the motion to disqualify Willis. And I'm glad he did. I've been looking at this a little more each day, and I think Willis should be disqualified. Frankly, if she were a woman of integrity, she would tender her withdrawal from that case, not necessarily her resignation from office, but her decision not to handle it. And here's why. McAfee in his ruling said, well, I've heard the evidence in this case, and quote unquote, there's an odor of mendacity, end quote. And so, I think I knew what mendacity meant, but just to double check it, I want, because it's not a word, it's not a word that comes up, every day. You're at Starbucks and the barista says, here's your cafe grande with 2 Splenda. You taste it, and there's no Splenda in there. Why, you've been engaging in mendacity, haven't you? That's not a word we use. So I looked it up, and mendacity means simply lying rather than telling the truth. And so what McAfee concluded...
Smells like a lie in here.
No, but I mean, really dwell in the moment here. Think about this. What McAfee concluded is that when Willis and Nathan Wade, the former prosecutor, special prosecutor appointed by Willis to handle this, when they appeared before the judge and responded to questions under oath in response to the motion to dismiss, the judge said there was an odor of mendacity. Now that's metaphorical speech. That's sort of like a penumbra, the emanations coming from the penumbra of the Bill of Rights. Sometimes the law is vague and people just don't have the balls to say what they mean. McAfee at 34, I know another 34-year-old who has no shortage of words. That would be Mr. Boyer. I mean, so look up, there's his smiling face. Put Boyer on the bench in the McAfee case, and would he have said, there's an odor of mendacity here? He would have said, you're fucking lying. And I think he just...
In my head, I have a bunch of kids sitting around, and then one of their parents walks in the room and doesn't really get the joke or know what's going on, and instead it's something's going on in here and I don't like it, right? That's kind of the idea that I get when he's like, there's the odor of mendacity, except for the fact that it was within his complete control to hone in on these things and he was the finder of fact, Norm, right?
And I think so. I think McAfee just backed off. He didn't do his job. He didn't reach the conclusions that were necessary. And in concluding that, notwithstanding this odor of mendacity, in concluding that it was apparent that Fani had lied, but not drawing the right logical conclusion from that, and that is a lying prosecutor is a minister of justice who is failing to live up to her duty of candor toward the tribunal. By failing to reach that conclusion, McAfee failed to do his job. And so I think he probably signed the certificate of immediate review to the appellate court so that somebody will. Maybe not. I don't know. But let's talk a little bit about the mechanics of that for you who are non-lawyers. The certificate of appealability was necessary because his order on the motion to disqualify Fani Willis was not what's called a final judgment. Final judgment, every dispute, X versus Y, state versus Trump, every dispute ends at some point. And when it ends, the conclusions are reduced to a judgment. And the final judgment rule says that you cannot take an appeal of rulings up until that point, until there is a final judgment. Appeals of things that are non-final judgments are called interlocutory appeals, and interlocutory simply means before a final judgment. So in this case, the judge was persuaded that the issue raised on this interlocutory appeal was so important, of such importance, that it needed to be decided immediately. And I think he's right. McAfee also concluded that that Fani engaged in "quote unquote," and Mike was asking me about this the other day, forensic misconduct for playing the race card at an African Methodist Episcopal church, by saying people were only picking on her because she was black. She shouldn't have done that. I think that's stupid on McAfee's part. She's entitled to play the race card if she wants. She's entitled to do it in a public forum. She's entitled to do it. It's just so long as her doing so doesn't create a substantial likelihood that this extrajudicial or out-of-court statement will have an impact on the finder of fact or on the jury in this case. In this instance, the public dispute is taking place months before any trial, maybe a year before a trial. Who knows when any of these cases will actually be reached? I'm just not sure that it's wrong. And so for him to say once again that it's forensic misconduct, it either has an impact on the proceedings or it doesn't, Judge McAfee. So, I'm going to start calling McAfee Half-Loaf McAfee because, he had the whole thing in front of him and he just couldn't figure it out. McAfee, the bottom line is as follows. She either lied or she didn't. If she didn't, there's no odor of mendacity. She's a liar. McAfee, she either engaged in prejudicial pretrial publicity or she didn't. There's no such thing as forensic misconduct that doesn't rise to that level. So Half-Loaf punted. The case is going to go up to the Georgia appellate court. Among the questions they'll raise is, whether there was a significant appearance of impropriety, or they'll consider rather, such that she should be disqualified. And the answer is obviously that there was.
So can you talk really quickly, Norm, about the standard that is reversible error? That is what the appellate court will be looking for in Judge McAfee's decision, reversible error. And I know we're talking about the standard being the appearance of impropriety. I think the Fulton County Code of Ethics states explicitly the appearance of impropriety can exist even in the absence of actual impropriety. So what is reversible error and how will that be applied here?
Well, so when you go to an appellate court, you're asking for relief. And usually that relief means vacating a judgment and sending back the case for prior proceedings, sometimes with directions. A reversal means, for example, you concluded X, but X is in fact the correct conclusion, and therefore they won't substitute their judgment for that of the trial court, but they'll send it back for further proceedings consistent with this ruling. So, for example, were the appellate court to conclude that there was that Judge McAfee, to give Junior Coltrane his due, that McAfee erred in concluding there wasn't a sufficient appearance of impropriety to warrant reversal. If he were to reach that conclusion, the appellate court would say, we disagree, there was, and we send this back with direction to enter judgment in accordance with the rule of this court. And at that point, McAfee would have before him an appellate court decision that says, this, there was a significant appearance of impropriety, and the odor, there was not just an odor of mendacity, there was actual lying, and therefore the court needs to enter a new judgment, and McAfee would then disqualify Fani. So that'd be that.
I'll let Junior have the McAfee reference because you just didn't hear me say it at the point that you were calling him half-love. But we'll move on.
So are you saying that Junior plagiarized you and took credit for some of the brilliance that
I'm just saying that Junior is exhibiting some Bud Light behavior. That's it.
You know, I think we should banish Junior for 72 hours as a result of that, you know. So anyhow, here we go.
Let's go to this. We won't spend very much time on it, but notable because there hasn't been very many updates in this case.
Yeah, well, I don't know that there is time to spend on it. You'll recall back in May of 2023, a retired Marine, Daniel Perry, was on a New York subway, a New York subway rather, when a street performer, a Michael Jackson impersonator with a history of mental illness, in a car began to perform and to demand homage and to demand recompense from subway riders in ways that many of them found alarming and somewhat threatening. When Perry got up to try to protect third parties and others, there was a confrontation between Perry and the man, and the man ended up in Perry's grasp. On the floor of the subway, there was a struggle and the man died. Now, Perry was arrested, and he was arrested for manslaughter. Again, when a person dies as a matter of law, that is a homicide, or well, that's death. When they die at the hands of another, it's a homicide. You know, there are a variety of forms of homicide. There's murder, manslaughter, negligent homicide. Under New York law, manslaughter in the second degree, which is what Perry charged, says that he recklessly caused the death of another. And so to recklessly cause the death of another means to engage in conduct that that carries with it a substantial and unrealistic and realistic rather, substantial and realistic possibility of harm, knowing that and engaging in the conduct nonetheless. He was also charged with negligent manslaughter, and that is, you know, failing to perceive the risk of danger. And so in this instance, Perry got involved. He intervened between a man who was mentally ill, had created a sense of anxiety and apprehension among third parties in a confined space.
Well, it was threatening to kill them explicitly, according to the testimony. It was threatening to kill them explicitly.
Yeah, you know, yeah, okay, you know, and so when he intervened and took that man in and took a hold of that man and subdued him, he was doing so to maintain order, or to create order in the subway. And in doing so, there was a struggle and the man died. Okay, that's a bad outcome. But the case illustrates, and I want to go through that one more time because I want to try to be a little more elegant about it and show you what's actually at stake. Strangers in a subway. One man begins to behave irrationally. His behavior, his words, and his conduct cause others to fear for their safety. At that moment, there is a sense of anxiety in the car, a sense of dread. One man, a former Marine, who is trained to respond in the face of anxiety and dread affirmatively acts and takes action to subdue the person who is causing anxiety, harm, and fear in others. In the course of that interaction, the man dies. That's what happened as a matter of fact, and we have a little bit of psychological data about how people were reacting to it. So now, for those of you who wonder how the law works, those are the facts. That could have happened in a subway car wherever there are subways, you know, Beijing, London, New York, Chicago. Each of those jurisdictions has a need to maintain order in its community. And we'll talk a little bit later about what law is. But the law is all about trying to create stable expectations between strangers living within a jurisdiction. So we have facts, the facts that I've described. We have an outcome, the death of a person at the hands of a third party, a stranger. That is a homicide. What will the law do about that? Nobody, when this law was written, about manslaughter in the second degree, thought about Perry, Mr. Perry, Daniel Perry, confronting the subway wackadoodle. That didn't happen. The law was written, it was a forward-looking law to talk about what might happen, the things that might go bump in the night in a society of strangers living together in the future. A prosecutor now is given a police report or a set of facts and said, this is what happened. The prosecutor's job is to act on behalf of the law to maintain order, to apply these general rules that were written prospectively years ago to conduct that occurs in real time on his or her watch. So the prosecutor has made a decision. The prosecutor has said, the facts that I am aware of rise to the level of or are sufficient to make applicable this law. And in my responsibility of applying the law to facts in a given jurisdiction, I'm going to charge Penny, rather. Excuse me, I keep saying Perry. So he made a charging decision. He charged Penny. And now the case will advance through pretrial motions and it will go to trial. And a jury will decide whether the law fits. Now, this is where things get extremely interesting because I view Penny's reaction to the man as understandable. The prosecution will have to say that given his training, experience in the military, he should have known that placing the chokehold on the man would create a substantial risk of death. In fact, he did know, and therefore he's guilty of manslaughter. Jurors, all that may be true, but a conviction may not be the right outcome. Just because the law fits doesn't mean it should be applied. Prosecutors have the ability, they have the discretion to either bring or defer or not bring cases based on policy judgments that they make. In jurisdictions, and the overwhelming majority of jurisdictions in the United States follow this rule, there is no such thing as jury nullification. In other words, jurors are not given permission to avoid the law's consequences. The facts either fit the concepts or they don't. And if they do, jurors must convict, and then a judge will sentence, and such factors as leniency or the conduct may be mitigating factors in the sentence imposed. Some jurisdictions, however, permit jury nullification. And jury nullification permits a juror to stand outside and say of the prosecution's evaluation of the facts, sure, this conduct could meet the definition of an offense, but charging the defendant in this case is unjust. And we're not going, and in the name of the community, we're going to stand back and we're not going to permit this injustice to occur. We're going to acquit, notwithstanding the evidence. Now, most lawyers aren't trained to think about what law is. Most lawyers aren't trained to think about what justice is. Most lawyers go through legal education and they go through the assembly line effect. They're taught these are the elements of the offense, these are the facts, these are the rules of evidence. Bing, 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 bing. And if all of this stuff can be done, well, of course it should be done. They're not taught to make judgments about what is or isn't in the interest of a community, or is not in the interest of a better society, and that's a problem in the law. And the Penny case illustrates that.
I think it illustrates a lot. I think it illustrates in terms of the decision to bring charges, second-degree manslaughter, criminally negligent homicide. I think it shows that there is not necessarily prosecutorial discretion when there is a person of color in a position as victim, even in this case. Right? We don't have to stretch our minds very far to consider the outcome of a decision by the prosecutor to decline to bring charges against Daniel Penny in this instance, Norm. So that's number one. Number two is that I can't ignore the fact that Governor Kathy Hochul just deployed the National Guard to the New York City subway station, right? And so the context that this fact pattern arises within is incredibly important. So we'll be looking at, you can talk more about the second-degree manslaughter intent elements, as well as the lack thereof in terms of negligent homicide, or at least the recklessness involved with that, with causality in applying the conviction for criminally negligent homicide. But if the prosecution is going to look at his or use his training, right, and that he should have known better, perhaps he didn't use adequate restraint, whatever else, I think the defense would be well served by also bringing to light his discernment and ability to determine threat assessments, right?
Yeah,
What was going on, and in terms of the context of all of this, right? It says a lot that somebody in his position who's riding the New York City subway, even if he's not from there, even if he doesn't do it every day, the problem is we now have a larger picture to look at, which is the governor of New York City, where this occurred, has deployed the National Guard to the public infrastructure system because the crime rates have risen to a level that is completely intolerable, right?
And that's important That's important to remember as you study this case, because this is one of these instances. We talked, the title of the show is Law and Legitimacy. And, the question is, in what instances does the law fit to create a sense that we're creating a community in which we all want to live, in which we can all flourish? And so what we have now is a situation, a fact pattern, a set of facts. It feels unsafe for many people to drive or ride the subway. A response by government putting armed law enforcement agencies, paramilitary types in or about the subways to increase a sense of safety. So that suggests that there's a real problem. This man, Mr. Penny, acted to address it. Now he's been charged with a law that probably had more to do in lawmakers' minds with how to deal with somebody who runs through a red light near a school district with their eyes closed. That would be a classic definition of recklessness. Penny was doing what the government failed to do, and there was a felt necessity to get it done. It seems to me that giving jurors or depriving jurors of the right to nullify, to say that the prosecutor misapplied the law in this case, results in a substantial injustice, and that Governor Hochul and others know it. Penny acted because the government didn't, and the government's now acted because Penny's actions show the need for acute government action. So we'll follow this story as it unfolds. It's extremely interesting. I think that we need to follow not just the application of the law, but the politics of it as well. Mike spotted a fascinating story this morning, I think, in the American Conservative, Miseducation of American Lawyers. And, I've been setting that up in the discussion of the Penny case, because early in the article, the essayist says, he's graduated from law school and he's now practicing law, but he really can't answer the fundamental questions. What is law? What is justice? And he can't answer that because that wasn't discussed in law school. His law school.
Let's use this video as a nice intro to the more philosophical exercise. I think this is a good anecdote.
Listen to Nancy Maldonado. She wants to be a judge on the 7th Circuit Court of Appeals. That's a court one step removed from the United States Supreme Court. It's the appellate court, the federal appellate court in Illinois. She was appointed a few years ago by Biden to be a district court judge. She's looking for a promotion, and here she is being asked some questions by a member of the
Senator John Kennedy.
I couldn't remember if he was a senator or representative, about language and a brief she wrote.
And are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify there, I was local counsel. Our Supreme.
But you wrote the brief. Tell me what you meant by assault weapon.
So first and foremost, I mean, we're going to let this go, but amazing attempt to deflect from the force of the question by saying,
what for? Because this
I was local counsel.
No, this is shameful. Show a little bit more. Mind you, this is a woman who wants to be one heart, and she's young enough. She could make it to the Supreme Court. She and Ketanji could go to they could have coffee together in the Supreme Court coffee shop. Hey, Ketanji, how is it up here? Fine. How do they treat women?
Senator Kennedy,
I don't know what a woman is.
I did not write the brief. The brief was written by.
You signed the brief.
AI?
Correct. I signed the brief.
You sign a brief. You're testifying to the court that everything in it is true, right?
Senator Kennedy, she's not testifying. She's
so they're your words in terms of the court, right?
She adopted sir, is what you mean.
You're correct, Senator Kennedy. I would never sign
what you meant by assault weapons.
I didn't know what I meant.
I am not a gun expert, and at the time, that brief I think was about 10 years.
Given the court advice about, say, ban assault weapons. What is? You told the court you were an expert. Just tell me what you wanted to ban.
Senator,
well, I'm not really sure.
Here today, as I said, I did not write that.
I just want the job.
I understand. At the time that
I look hot in my horn rim glasses.
I want to know.
I don't remember the exact definition of assault weapons.
Oh my God! And whatever is
you submitted a brief to an appellate brief. You signed it, and you don't know what. And you said abolish assault weapons, and you don't know what you wanted them to abolish?
Well, that's about
Senator,
right. Yeah,
at the time
but I do want this
that
job.
I signed the brief, I read the brief, because our Supreme Court required someone, an Illinois bar member, to
Nancy.
sign the brief. I
Nancy,
was not
can you sell
responsible
pencils
for
outside of
researching the
Wrigley Field?
content.
You were
I-
responsible for the brief.
Absolutely, absolutely. And sitting here today, I do not remember the characteristics.
Here, I have
of-
no idea what I
of-
signed,
that
why
were-
I
that were
signed it, who
cited in the
Nancy Maldonado
ordinance
is.
for the assault
Okay, so here
weapons.
we come. Cut that. Here we have the problem of Heraclitus. Okay, and you were wondering earlier why I talked about time slipping into the future. You know, you have a stream, let's say, on a property or on one of your favorite hiking trails, and you walk through it on a Monday, and you go to Tuesday. Is it the same stream? Of course it's not. All the water that flowed through it on Monday is since gone. There's different water there, but yet you identify it as the same stream. Or Zeno's paradox. You shoot an arrow at a target, right? And the arrow at a discrete moment in time, it's halfway toward the target. Then it's halfway again. Does it ever arrive? Of course it arrives. It overcomes the halfway problem. But that's a matter of experience, not logic. Nancy. You meant something at the time. You can't pretend to not be the same person. The stream that is Nancy Maldonado may have discrete breaks in it, but it had some intention. It had some comprehension of what it was doing. And you can't very well sit up here now and deflect to avoid a political landmine and be any more credible than Justice Ketanji Brown. And I remind everybody of our nursery ditty. There was a justice had a name. Ketanji was her name. Oh, K-T-N-J-I, K-T-N-J-I. Ketanji was her name. So Nancy's having a hard time up there. And it sort of, I don't know if it really illustrates the point being made in the American conservative. It certainly shows how craven a person will be in their effort.
Not even craven, but incurious. I think that the connection I want to make to this, her incompetence is on full display. And this is deeply troubling to me. I think the fact that she is in my age cohort and she has ascended to this level of potential trust and power, frankly, right, is deeply troubling to me. But there is such an incurious nature that is endemic to sort of this millennial kind of like zillennial demo right now, right? That is just, I'm signing my name on something because there are other people involved, and there's no way that if I'm going down, everybody's going down. But by the way, we're doing the right thing here, right? Principally, the top water of American culture is flowing in the direction of, guns bad, and I don't need to have ever held a firearm, taken a concealed carry class, have done a ride along with a law enforcement officer, or have any working lexicon that would convince someone of average intelligence and experience that I even know what the fuck I'm talking about. That is what I am worried with. Principle.
I'm not. It's the same sort of disingenuous tap dancing that has become the standard routine of confirmation.
It's NPC behavior. It's non-playable character behavior. There is this recognition inherently from my end that this person has never applied themselves critically to anything. It's just, I'm doing this now, and here I go, and this is what I need.
No. I disagree with you. I scented an odor of mendacity. She'd gone to the Fani Willis School of Integrity, and that is, she'll say whatever she needs to say to get what she wants when she wants it. Hey, special greeting to a new listener today. It's William Bauman. Finally listening live. It's good, Bill. Now that you've been set free and liberated from the preconceptions that apply everywhere else, come back daily, bring your friends, linger for a while. So this Miseducation of the Modern Lawyer piece, I recommend it to anybody.
Jackson Barrett agrees with you, by the way. Jackson Barrett says, Michael, they are playing stupid. It is perjury. So he adopts your view of this.
I think of course he is. Of course I'm right. When have you known me to be wrong in the last 30 seconds?
I just happen to know how how unimpressive many people of my age group actually are. So that's where we differ here. It is completely possible in my reality that this person has existed to this level of whatever, and whomever is pushing her in this direction is really who is pushing her in the direction principally for certain issues. But she does not appear to me clearly as anybody that should be taken seriously, because I don't think she could rip her way out of a wet paper bag. Frankly.
She may not, but if your ass is in a sling and she's your judge, she's the person who's going to decide what rules of law apply, and she's the person who's going to see to it that justice is done. Because if you look at the rules of civil and criminal procedure, the rule 1 of the federal rules of civil procedure want prompt and efficient administration of justice. I'm not sure what rule 1 is on the criminal side, but the great aspiration of our courts is to see that justice is done. And the thing that is so amazing about the Miseducation of the Modern Lawyer piece is he reminds us that you can get through a 3-year legal education without ever really having a discussion about what justice is. So let me, and we're going to have to talk more about this, Mike. I see we've talked through our listeners' time, and we're now out over our existential temporal skis. But here is the deal. Justice matters. And so, for example, there was a fantastic book written in either 1973 or 77, somewhere in that range, by John Rawls. It's called Justice is Fairness. And so Rawls wanted to, and this was based, it's a longer treatment of an earlier essay that on justice as fairness. And so Rawls asked the question, what is justice? How do we know when we have behaved justly? Is it just an intuition, in which case what may be just today and satisfy an intuition is unjust tomorrow when our intuitions change, our standards change, our perspectives change? He wanted to have a rational theory of justice, and so he banked it in social contract and or game theory. And his notion of justice as fairness was designed to provide a working definition of what justice looked like in a variety of contexts. Now, I remember, because I was in graduate school and teaching before you were even born, Mike, I remember reading the book and being told to read it. We had a seminar on it. This was at a school I can't name because you don't like it when I name drop. And I thought, this is garbage. Why this elaborate infrastructure? Why this elaborate attempt to come up with a set of rules that permit us to determine what is or is not just in a particular outcome? And where do these rules lead us other than to a sense of choice, into the blind place where we're left alone with ourselves and we must respond to hidden imperatives and decide about fit? But that was unfair to Rawls, because the book has turned out to be enormously influential, and over the past half century in Anglo-American jurisprudence has probably been quoted more than any other book on the nature of justice. We'll talk more about justice. We'll talk more about law. We'll talk more about John Rawls maybe tomorrow morning. But take a look, folks. This is an assignment for you, Dawn, when you get back from the pickleball court in a couple hours after you've bonded with your sense of community out there and bemoaned the state of the world with other people who like to stroke strangers' balls with a paddle. And I'm not talking about your being in an S&M show. I'm talking about your being physically fit. Read this essay, because I want to talk more about what law and justice is. I think that's the discussion we need to have, especially in the 2024 election, where we're going to just be bombarded with this rhetorical nitwittery, and inspired to rage and inspired to action on the basis of dark emotions. What we're all craving is light. What we're all craving is some sense of an ability to come together on common norms and commitments. That's where the action is, and that's what people are not being taught in law school. And as that essay points out, it's to our collective detriment. There are things you can do about it, books you can read, discussions you can have, and we have those discussions here on Law and Legitimacy. Quick pivot. I've got my act here for tonight. Mohegan Sun. I've only got 5 minutes on stage. I'm a baby comic trying to emerge into a more significant comedic role, a role I'll get to play in part in Atlanta next month, where I'm being given more time. But in this tonight's performance at the Mohegan Sun, 10 p.m. Comics Roadhouse, it's going to be a lawyer's account of his struggles along life's way and the transforming impact of some events on how a person can look at law, life, love, and justice. Come on out. I promise you it'll be interesting. You may laugh, you may cry, you may do neither, in which case you'll have wasted the admissions fee, but at least you'll have come to see a good show.
And then tomorrow, 12 p.m. Eastern, still waiting on a few more details, but we will be on the Laid Back Law show. You might know it as Laid Back Law with Nate the Lawyer and the crew over there. So Norm and I will be there 12 p.m. Eastern time. Live stream.
Laid Back Law. I mean, we have to act mellow. I can't drop F-bombs and say, that's ridiculous.
This means we have to be supine, right?
Oh, all right. What kind of pine?
Anyway, so that should be fun. No idea what kind of criteria or topics we'll be analyzing. So that's always great to walk into an ambush, but it'll be great to kind of elevate the Law Pod Daily platform a little bit more. Was delighted to see Nate the Lawyer in here yesterday, giving us compliments on the content itself, and then also spent some time on the phone with him yesterday. Great guy, and I think that is just sort of some emphasis on the fact that Norm and I will be moving much quicker to raise the profile of this show and to honor those of you who have been with us since the beginning. So Norm, I'm looking forward to that tomorrow. Really am looking forward to hearing how your night goes tonight at Mohegan Sun. What's the expectation in terms of who is there a second and third round, that kind of thing?
I have no idea. I got the invite, and so it's like, sufficient unto the day is the evil therein, I think is written in the Old Testament somewhere. And this is a challenge, and I'm on. So I've been in touch with somebody out in LA who says, there are some folks who are interested in you, and they might be interested in how you came to be and what your sense is and where you think you're going. And so he's encouraged me to consider writing a one-man show. And so this is a snapshot about that. And it will talk about moving from one point in the law to another in ways that I hope folks will find amusing and entertaining. Certainly revealing. I'll be taking a big risk tonight. I'll put it on the stage, and it won't. If I'm booed, it won't be the first time. If I'm loved, I'll take the love. If people are indifferent, I'll think, maybe stand-up comedy isn't for me.
Well, and just I'll put an asterisk next to whether we will be here for our normal time tomorrow morning at 8 a.m.
We'll be here. Okay,
good deal. So we'll see you tomorrow at 8 a.m. Eastern time, just like you can find us here every Monday through Friday on YouTube at LawPod Daily. You can also find us on X at LawPod Daily and Rumble at Law and Legitimacy. Guess what, Norm? On the topic of Rumble, and some of you Rumblers will be delighted to know that a miracle has occurred, and we can now see the paltry viewership numbers on our static stream key.
Well, there you go.
So we haven't been able to see any data on that kind of stuff from a public side, and then all of a sudden, the last couple of videos have our really sad numbers. But hey, they're there, right? We got them back finally. So whoever worked through the swamp of Rumble and told them to unlock our stuff, thank you.
Thank you. See you all tomorrow.
See you tomorrow, Norm. AMF, yo yo.
AMF.
AMF, yo yo. Bye.
You.